Hello everyone, welcome to Court with Krissy. Melissa's money got funny, but today the state has a sweet deal for the defendant. Avoid prison and half-off restitution. Sounds too good to pass up. Or is it? And who knew Judge Ricke was this funny? I hope you like it. Court with Krissy is now in session. You got a belch.
County, Kansas, case entitled State of Kansas versus Warren William Camplin III. It's case number 2024 CR 316. James Watts appears as defense counsel. Mr. Camplin appears from a court security maintained Zoom location at the Butler County Judicial Center. Amber Norris appears for the state of Kansas. This matter comes before the court at this time for pretrial conference. What announcement is made at this time, Mr. Watts?
Your Honor, after discussion with my client, the state had made in this case a more than fair offer in this matter to resolve this by a misdemeanor with significant restitution. My client does not believe at this time he could accept that offer. He would ask to continue this case. Well, Mr. Camplin, did I misstate your position?
Mr. Camplin?
The fact that I don't want to do the thing is only because I don't want to go to jail today.
Well, Judge, as I told you,
that's all I had to say.
If the offer is accepted, I don't believe the state's going to be asked for you to be in custody today. But as I mentioned, the court has the authority to act in its own regard.
I know. That's what I'm afraid of.
Well, Mr. Watts, is the issue of restitution settled between you and the state?
Judge, the state has asked for a restitution figure of what would be $23,275. My understanding is my client is willing to accept that figure. He obviously does not have that funds. He would have to be on a payment schedule to make that payment. His concern is in large part whether or not he would be placed in custody today. As I explained to my client, I don't believe that's likely to happen, but the court has the legal authority to do so.
All right, I'm just curious. What is there a plan for restitution payment here? I understand the aggregate amount that's been apparently agreed on, but is there a plan for repayment?
Your Honor, my client is on a Social Security payment of a little over $800 a month, between $800 and $900 a month. I don't remember the exact figure. He is hoping to get some assistance through the VA that might be able to supplement that somewhat. But that is at this point his sole source of income. So he's going to have to be making monthly payments. And I suggested probably $100 a month. That will be difficult for him because he is effectively homeless at this point. As Your Honor well knows, because Your Honor did the preliminary hearing in this case, there was a bank account that has now been frozen by the court. My client no longer has access to. At this point, I don't know how much money is left in that account. I don't have access to it either. Presumably, whatever funds in that bank account still exist would be surrendered to the state in payment of that restitution. The state had originally offered a restitution figure of $45,000, I believe $550 if I remember correctly. Yes, $46,550, excuse me. $46,550. I noted to Ms. Norris that realistically my client has no realistic way to pay that figure back, even on a monthly payment schedule. Her response was that perhaps half of that number could be agreed to my client, which would come to $23,275. He does not have $23,275 in cash or available assets to pay it immediately. He would have to be making irregular payments, and he has a limited income to do that. I presume that the remainder, the other half of roughly $100,000 medical bill, which is the issue in this case, is the other $54,000, give or take, is remaining in that account. I don't know because I don't have access to that account, but I presume that that figure is roughly what is remaining in the account. If that makes any sense.
Not entirely. Who else has access to this account at this point, Mr. Watts?
Your Honor, I don't believe anyone else has access to this account. Ms. Morton is in a treatment facility. Although she has legally access to that account, she has no actual way to access it, as far as I know. I know that Mr. Camplin was barred from access to this account by this court in October of last year. I don't know of anyone else that has access to that account.
Your Honor, I haven't gotten an update from DCF about who has access to the account, but it is Miss Morton's account. It is not the defendant's account. And it was basically the bulk of the money in the account was from the proceeds of the sale of her house. So the account is for, basically is Miss Morton's, the victims. So the restitution would not be coming out of that account necessarily. That's money that's utilized for her care and whatnot. I suspect that they've accomplished a guardianship conservatorship because that's what they were working on through DCF, and that whoever that is has access to that account and interest at this time. But I have not gotten an update from DCF about who that is.
I just hate that these funds might be frozen when there is an owner of that account that needs the benefit of those funds.
Your Honor, you have not allowed this defendant to have access to the account, and interest froze it temporarily until the defendant couldn't have access to it anymore. And as far as I know, it's not. Miss Morton would have access to those funds, although she is not in a position to do that on her own.
All right. Again, my concern is that there's no one exercising control over those funds for Ms. Morton's benefit.
It's my understanding
what you said about DCF. You're asking me to trust that DCF took care of something, and sometimes I have difficulty with that.
And all I know is that they had started the process several months ago for guardianship conservatorship, and I mean that was probably maybe July or October. I mean it's been quite a while ago that I was told that they started the process. But like I said, the bank only froze it predominantly because they didn't want the defendant having additional access, because he kept taking money out in large chunks, like $10,000 at a time.
All right. Condition on this court being able to take a successful plea from this defendant. What new charge is the state contemplating here?
Your Honor, it would be misdemeanor mistreatment of a dependent adult under 215417 A2 B B2F, which would make it an A person misdemeanor, and it's under the basically it's the misdemeanor version of the alternative, which is basically a violation of a power of attorney.
All right. What plea is it contemplated, at least, Mr. Watts, that your client would be entering?
Well, Your Honor, if my understanding was correct, my client was seeking to continue this case. Mr. Camplin, do you now intend to enter a plea under that, either a guilty or a no contest plea? What do you want to do?
I cannot go to jail today. There's just too much happening, and too many things would suffer in the process.
Well, sir, as I told you when we met privately,
And it doesn't have anything to do with money.
Sir, I don't think that's likely to happen. But as I mentioned when we spoke privately, the court has the legal authority to do so. I don't know that the court's going to do so, but has the legal authority to do so. And I cannot guarantee you what the court will do.
I understand. That's why I'm worried.
So how do you wish to proceed?
Oh, Melissa can say yes and no and make decisions.
Okay. Sir, that's not the question I asked you.
I know it's not. I just wanted to say that.
how do you wish to proceed today? You can
Jury
accept the
trial.
misdemeanor, or you can set the
Jury trial. I need time. The witnesses I need are no longer staff at hospitals, and I'm having trouble locating them. One of them might even be out of state. I don't know yet.
and Your Honor.
All right, Mr. Watts, if this will help bring some closure to this discussion. This court, if it accepted a plea even to a misdemeanor today, I'm going to defer sentencing. This court wants to know exactly what the status of these funds are that Mr. Camplin previously had access to at Intrust Bank. I prevented him from getting in there. I want firm information, verified information, which I presume the county attorney's office can provide this court with a little time, as to exactly what's happening with those funds, how much is in there, and what this court needs to do, if anything, to facilitate these getting to the benefit of the victim in this case. So I will be deferring sentencing. And I don't know if that helps this discussion or hurts it.
That
What
means
does that?
that means, sir, that the state is not going to do sentencing today. You would not be taken into custody today.
Mr. Camplin, what do you want to do here?
Jury trial, Your Honor.
Your Honor, if my client wants to have a jury trial, he believes that there are witnesses that would support his theory of defense. I have encouraged him to let me know who those witnesses are. And as I told Mr. Camplin, I must know who they are, how I can reach them in order to subpoena them, and what it is they're expected to testify to in order for me to consider subpoenaing them as a witness. Mr. Camplin has some difficulty doing that because he's having difficulty finding the witnesses he believes he needs. I would ask on his behalf to set this matter over so he can obtain and find and identify those witnesses.
All right, I understand the nature of the request. I guess I want to make sure I understand the defendant's position here. The state has made a misdemeanor plea offer to you with a 50% reduction from their perspective in the restitution that you'd be ordered to pay. If the court were to accept the plea today, I've already related that I'll be deferring sentencing to a later date because I need more information regarding the funds in this account. So you're turning that offer down?
Explain that to me, Your Honor. I didn't.
I thought I just did.
You did, but I was listening to what you said before, and the part. Could you please repeat it?
All right. The state is offering that they would, upon successful plea, amend the charge in this case downward from a felony, a presumptive prison felony, to a Class A misdemeanor. Class A misdemeanors in Kansas are punishable by up to a $2,500 fine and up to 1 year in the county jail, or both. The state has also, as part of this plea agreement, apparently agreed to discount the restitution amount from $46,550 to half that figure, $23,275. And at sentencing, this court would have to work out with you some understanding regarding a payment plan on this restitution. By accepting their plea, it resolves the case. There wouldn't be a jury trial, but there would be a sentencing date where the state would return with more information that this court is desiring, and then you would be sentenced at a later time.
I understand that, Your Honor, but no one understands my position.
All right.
Laws
What is that exactly?
Laws have been broken. Laws have been broken, and I'm not allowed to talk about it.
Okay. I'm really just focused on what laws you might have broken.
I understand. I know. Yeah. That's what I just was trying to say. I'm sorry, Your Honor. Go ahead.
No, you go ahead. I just want to make sure what your position is today.
Your Honor, this jail thing has me worried. And I have a polytrauma appointment in June. I just had one 2 weeks ago, and I have another one in June. And I have a polytrauma, and then a podiatry appointment next month, which they just rescheduled for They want to do surgery on me, but they can't put me under. I have to be awake. And I'm trying to decide whether or not I want to be awake for that. I don't know if you understand. I'm sure you do. But anyway, I have a letter that was written in 2017 from a doctor that the animals are support for me. I can't live with the fact that if I'm put in jail or something, that no one will be there for them. I have other things in storage that I'm trying to work on because the storage unit that I had was bought out by another group of people, and the payments for the storage I was making were canceled because they had a different bank account, and I got behind. And I'm trying to work with that also. That's not just Melissa's things, but also mine. A treatment center that Melissa was going to go to in 2020 has now been burned down in Malibu, California. So in a way, I'm kind of glad maybe she didn't go there because all of Malibu is burned to the ground. But that was our whole problem since 1999, is I couldn't get her to go into a treatment center. We stayed engaged, and it's been an off and on thing for me to try to get her away from the things that she did. I can't mention names of her friends because I have children in Wichita and grandchildren, and I don't want anything to happen to them. The fact is, though, that what led me up to having to sell the house, that wasn't the plan. Melissa was supposed to be home in December 2020.
Mr. Kemplin, I'm really not sure what this has to do with your decision.
I know, but that's what led me to the point of January 4th. I think the house was sold. The man that bought the house abandoned me on promises that I gave him such a good deal on the house. I ended up having to do the promises he made with money from Melissa's account because he quit midstream, and he fired one of the moving teams, and one of the moving units I was in, when I got help to try to make a hallway from people so I could get back and forth and see where everything was, in the very back on the left, and this is the truth, on the very back on the left, and this was last year in 2024, was a spot that was 12 feet by 6 feet wide, 12 foot long, 6 feet wide. Nothing was there. And then I found out a month and a half ago that the storage unit next to me, someone was living in there. And there was a crawl space that I saw when I saw that opening, but we filled it quickly and piled up as high as we could. But what was someone doing living in a storage unit with a crawl space into the next one with a 12 foot by 6 foot area? I'm still trying to find that out. But that's the kind of thing I've been dealing with. I've been having to pay people that I wasn't supposed to have to pay for things that were promised. And the thing that was promised to me is they would pack everything because I can't. I'm disabled. They would move everything to a storage unit for me, which they started doing, but they drug it on and on. And instead of being out of the house in January, like I wanted to be, I didn't get out until June. And I lived in a car for 30 days, and I couldn't get to the bank money I had a deposit for a house in Chanute, Kansas, but they wanted cash, but I was going to go up and give them the money. But I couldn't because the bank account got closed for me to be able to do that. And I ended up having to buy something to live in, which is basically a trailer. It's parked in somebody's yard right now because he gave me permission. I don't even know the guy, but I asked him if I could because they put a tow notice on it, impound notice. And I'm running an extension cord from someone 3 houses down. It's a 250-foot cord to run a space heater and to charge my phone. That's what I've been doing since November. Was it a lake?
No, I'm not sure what
I
any of
know,
this
I
has to
know.
do
I
with the
understand.
decision that you need to make today.
Well, that's a lot of it for me because just dealing with everything I've had to deal with has been, it's not just, it hasn't been for me. This is all about Melissa. For instance, me being able not to
Well,
see Melissa doesn't, it hurts me, but it's more devastating to her. The fact that she probably in her mind thinks I abandoned her or something, you know?
who's managing her affairs right now, Mr. Camplin? Do you know?
I don't know because
She does have a guardian
they
and
call
appointed
me,
that person.
they call me from the hospitals and the life care center, but I'm not allowed to call them or go there. So I don't know what's going on. But I did know at one time. I have witnesses and people that I've sent pictures to of Melissa's condition over the years. But I know that's not the thing. It's all about the money, and that's what I wanted to mention today. If we could find a way to follow the money, not only from me, but all the way back to a point where I have a letter from someone, which in 2021, that says, why would they be looking into Melissa's money in 2021? Or why is she not being able to walk without help? You know, it all, if you follow the money, Your Honor, this is more, it's in depth, like I can't even understand sometimes because I trusted everybody to help Melissa.
All right, the state's case really involves money from December 22nd of 2023 forward.
I didn't.
I'm not sure what relevance 2021 would have, but
well, the money wasn't deposited in the bank account, I don't think, until January. Can't remember. But
so really, I'm not going to get an answer today. Is that right, Mr. Camplin?
you want to know
if you want to accept the state's misdemeanor plea offer?
It's tempting, Your Honor. It sounds like something I would like to do to serve a probation and to pay a fine. But the problem is I don't know whether I can trust that or not. I mean, I could trust that I'd have to pay the money back. That's a done deal. But I can't sit here and honestly say that I trust that I won't be put in jail.
Well, if you're wanting me to make a guarantee, I won't.
Pardon?
That's an issue for sentencing, which I was going to defer.
Defer.
Put off, postpone.
He's doing a later date.
I need some additional information.
I've been told by people around me and I'm supposed to go see him, as a matter of fact, but I haven't had a chance. A prosecuting attorney in Wichita that might be able to help me with this. No, I know that sounds.
Well,
this
prosecuting
was told
attorney in Wichita won't represent you and probably won't even
no,
advise
they won't. But I'm being told that I need to take this to jury trial by a lot of people.
Really?
Yes.
Ultimately, that's your decision.
I understand, and I didn't. How do I explain this? When I transferred from Melissa from Olathe Medical Center to Life Care Center, I didn't pay attention to what I was signing. I really didn't. I was in such a shock of what had happened to her that I had to find a place, and all the beds in Wichita are everywhere. I couldn't find an empty bed anywhere. The only place I could find an empty bed was Andover at the Life Care Center. But at the same time, when I started signing the papers, my concern was just to get her taken care of when I found out she couldn't walk anymore. So I just started signing papers, to try to take care of her. And that's
Mr. Camplin, I have no doubt that your attorney's already gone over this with you, but I don't know that I have. So I will point out that you are being charged with a level 5 felony.
I understand that.
I
And
have
that's
no
no
doubt
good.
that Mr. Watts has gone over with you that the sentencing range is about from 2.5 years in prison to about 11 years in prison. You do understand that, right?
Oh, I do. Believe
Okay.
me, I do.
All right. Again, I trusted that you knew that, but I did want to make sure that you were aware that if you were to be convicted of the felony by any means, that's what you're facing.
Right. Your Honor.
Okay.
Your Honor, I expected this to happen. This is something I've been dealing with in Kansas since the year 2000, but it actually started in 2002. But I can't get
I don't want
into
to go
that. I
back to
can't. I know. I
I've
can't
only
get
got
into
so
that.
much time.
I understand that. I wish we had more time, Your Honor, because I have witnessed things and know about things in Kansas, especially Wichita, that some of it can be proved because they were caught, but some of it can't. And that's why I can't talk about it all and give names out. Because, like I was telling you earlier, I have too much happening in my life to endanger anybody else. And I know, but I'm saying that I tried to keep Melissa in the hospital in November 2019. One day I went to visit her to make sure she was okay. And somebody, one of her friends, had gone there and checked her out. I ended up taking care of Melissa myself from November to May. Showers, feeding, help walking her. I had no problems with it. I even got her to work on her curvature of the spine to where she was walking straight up and down. And then she had another stroke in May, and she kept repeating my name. And I couldn't figure out why she repeated my name. And then I took her to the hospital. And it turns out she had what's called a traumatic brain injury stroke. And that's on paper. And it's why she kept repeating my name.
Well, I keep repeating your name too, but I don't get an answer.
I know.
All right,
it's
counsel, we need to get somewhere with this. The only thing I have before me at this time, Mr. Watts, is his declaration that he's not going to plead, that he still wants a jury trial. That's the one thing he said that I did understand. And I get the distinct impression that to be able to defend him properly, you're going to need some additional time to subpoena defense witnesses. Did I understand that correct?
That's correct, Your Honor. And
Right.
Mr. Camplin is going to have to name the witnesses that he believes support his theory of defense.
That's between you and him.
I understand
I
that.
did send one name. Your Honor. I'm sorry, Attorney Jay Watts.
I'm going to do a special setting for pretrial conference in this case, in person. This is an in-person proceeding. Mandy, I'm looking at the afternoon of Tuesday, April 1. Certain irony with that being the date. But I'm looking at the afternoon calendar, and I think we could work in this case for an in-person courtroom proceeding. Do you agree, Mandy?
Yes, at 2 or 3 p.m.
Okay. Mr. Watts, your calendar during either one of those time slots.
April 1 at, right now, Your Honor, I don't have anything set on April 1, so either of those would work.
Okay. I think I'm going to choose the 3 o'clock time slot for this case.
Your Honor, does that have a, are you just setting a status hearing, or are you setting a jury trial to go with that?
I'm setting a jury trial to go with it.
And the jury trial would be when?
That would be the following week on the Butler docket, which would be Tuesday, April 8.
Your Honor, I'll just be getting back from out of town, so I'm really not available on the 8th. I could do the 1st for the pretrial, but I'm not available to start jury trial on the 8th.
All right. I want to check speedy trial scheduling then, Ms. Norris. The court's going to determine the continuance from this date to the eventual date set is going to be chargeable to the defense.
And Your Honor, I believe that The last one was charged to the defendant as well because he failed to appear.
Yes. I would concur. So we have about 3 months from arraignment to that date in January. Then later, Mr. Camplin apparently appeared by phone on a kind of a surrender following a declaration of bond forfeiture bench warrant. Obviously, the continuance that was required by his non-appearance is chargeable to the defense. All right, I think we're in decent shape on speedy trial. Mr. Watts, would you and your client have an objection to setting this case for a pretrial status conference without actually having this live for jury trial on the April calendar?
No, Your Honor. I don't believe my client would have an objection to that.
All right. Mr. Camplin, I'm going to set another court date. We're going to look at this case again on April the 1st, but I'm not going to put the case on the trial calendar for the following week. If you still want a trial on April 1st, you're going to be on the May docket. Okay? So in fact, I think I'll just go ahead and do that in an abundance of caution. I'll set the case on the May trial calendar. And let me come up with that date here. The case is moved to the trial calendar of Tuesday, May 20.
Yes, sir.
I'm going to set this case for what I'll establish as pretrial conference for Tuesday, April 1st. I don't want that much time to pass before we review this case again. Ms. Norris, with that direction given, that we're going to set a pretrial status conference for 3 o'clock, Tuesday, April 1, in person, courtroom B, Butler County Judicial Center. Mr. Camplin, you're ordered to appear at the Judicial Center in El Dorado at that time. Same building where you are today, you'll just be in a different space. So make sure you get in there a little bit earlier before 3 so they can get you to the right location. Okay, Mr. Camplin?
Yes.
Your Honor,
We ask that the county attorney's office inquire with DCF as to the current status, as to how the alleged victim in this case's money and interest bank is being handled, if there is a guardian and or a conservator in place, and who it is. And if you can get that information and have that available for the court on April the 1st, you're certainly welcome to share it by email with Mr. Watts and I prior to that time. But if not, I would ask for that report Tuesday, April 1 at 3 o'clock. If you need a court order to obtain that information, this court's going to be inclined to sign it.
Yes, Your Honor.
And DCF may require that.
So I'm clear, Your Honor, that April 1 date is an in-person courtroom with all parties in the courtroom.
It is.
Yes, sir.
Yes. April 1, 3 o'clock. Again, Mr. Templin ordered to be there in person for further proceedings in the case. So in light of this, continuance chargeable to the defense. This case is removed from the trial calendar of next week. Again, it's deferred over for jury trial purposes, if necessary, to the May docket. In person, courtroom B, starting 9 o'clock a.m. Tuesday, May 20th, unless reset by future order. All right. Mr. Camplin, anything change from the time I talked to you last until now?
Yes, Your Honor. Melissa has been moved to 2 different hospitals since, with conditions that she wasn't suffering from in June. Just to let you know that I've been called by both Life Care Center and the 2 hospitals where she was at. And she is coherent and can answer yes and no. Just so I want someone to know that. And I think we all should know it. Melissa can answer yes and no and can make decisions, even on surgeries.
Okay. Well, I hope she's competent to manage her own affairs. I doubt if she's competently able to manage her financial affairs at this time.
Well, no, because the reason is.
No, okay. All right. We don't need to go any further.
I know.
Again, I'm going to ask the state to see who is indeed managing her state of personal affairs, in other words, her medical affairs, as well as her financial affairs at this time. Probably a guardian and conservator has been appointed, or it's in the process of being appointed. But I want that information before the court the next time we meet, if not before. So appreciate that, Mr. Camplin, but I think our business today is concluded. I think we've gone as far as we can. And we'll review the case again Tuesday, April 1, 3:00 p.m., courtroom B, Butler County Judicial Center.
And Your Honor, if I may, I apologize. I've got to be in front of the 2:30 here in a few moments. I need Mr. Camplin, but I can't right now. Mr. Camplin, if there are witnesses that you wish to be subpoenaed for that trial date now set for April 20, by that May 20 is the trial date, May 20. By the April 1 date that has been previously set, April 1 at 3:00, I need to know who you want to call as a witness, how to contact and reach them so I can issue a subpoena, and what it is you expect them to testify to. If I can't know those things, I can't call them as a witness and put them on the stand. Okay? And we talked earlier about hearsay. You can't testify to what other people told you. I have to have those persons present. Okay?
Correct.
I need to know who they are. Okay?
And yes. It's okay.
And I must have them by the April 1 date so I can get them subpoenaed. Okay?
All right. Understood. I'm working on that really hard.
Okay.
As a matter of fact, a thumb drive is being mailed to me, and I haven't received it yet. And it's got a name on it I need.
Because once I have that list, we'll need to talk about who they are, what they might say, what the evidence would be, and other things which we don't want to talk about here. We're beyond what we can do here.
I understand.
Call me very soon with that information so we can get it ready for trial if that's what you wish to do. Okay?
I will.
Lastly, if there's a court security officer with Mr. Camplin, would you make sure he has a card that he can take with him, setting forth his in-person date, April 1 at 3:00? Okay, excellent. He's
Looks like they've already done it, Your Honor.
Fantastic, and I appreciate their assistance. All right, if there's nothing further at this time on the Camplin matter, again, it's taken off the trial docket for next week. We've got future dates set. And at this time, this case is in recess, and the meeting may be ended for all.